Good afternoon. Thank you for joining us, everyone. On behalf of Foley and Lardner's Fashion, Apparel, and Beauty team and Confiance Cosmetic Group, we're very pleased to have you join us as we explore clean beauty today. We will first discuss regulatory and advertising issues and then IP topics. We're happy to take questions at any time, and we'll also leave time for questions at the end. I'm Carrie Lee Sharon. I'm a partner in Foley and Lardner's Washington, D.C. office in our IP department. I counsel clients on patent matters, including for consumer goods, medical devices, drug device combination products, and packaging. Brad?
I was on mute. I'm Brad Roush on I'm an IP litigator in our Washington, D.C. office. I help clients with all sorts of matters, electromechanical, chemical matters, including recently a cosmetics case that related to clean beauty products, and I'm happy to be presenting here today.
I'm Reba Ahmed. I sit in Foley's Chicago office, and I'm a member of the IP litigation group. I'm just starting my career, so I'm diving into the cosmetics regulatory space and hope to continue building my expertise there. Today, I'm excited to talk about an upcoming case that addresses consumer transparency in marketing cosmetics in the absence of regulations.
Afternoon, everyone. My name is Aryan Jabari. I am an associate in our New York office in the trademark copyright and advertising group. I'm not part of any witness protection program, although I look like it with the dark silhouette. I've done everything to get this lighting right, but I can't quite figure it out. I'm an associate in the New York office, as I mentioned, and I'm also a member of the Fashion, Apparel, and Beauty group, and in particular, the Cosmetics and Beauty subgroup. And prior to joining Foley, I was actually in-house as Associate General Counsel for Mesa, which is a private label supplier, and how I met the lovely Claire Bing.
Thanks, Ari. Hi, my name is Claire Bing. I'm CEO and founder of Confiance Cosmetic Group. We're a group of individuals who help private labels, brands, distributors, manufacturers, retailers with their regulatory and quality needs, both in the United States and globally. And so we'll kick it off to go to the main topic today, what is clean? So I think this is a topic that everyone wants to know, especially people who make clean products. What is clean? And there's one problem overall with the entire clean beauty world is the misinformation that's going out. So you'll often hear YouTubers or maybe someone from your marketing team bringing a TikTok or something to you, and they'll say, we need to make the ingredient list smaller. Long ingredient list means it's not clean. Here's 500 YouTube videos where every single person's saying, I have a really long ingredient list. This is not clean. So what do I do? And really the misinformation is a long ingredient list doesn't necessarily mean it's not clean. And also if you have chemicals in it, it also means it could potentially be clean. It is a lot of information. So here I have a long ingredient list that you can see where it has lots of scary things like allergens, like citral. It has things like aspartic acid. Also on the right, you see a chemical structure. So for an average consumer, from the information they're being fed through YouTube, TikTok, and blogs elsewhere, they're being fed that this is not clean. Actually, the fact of the matter can't be any different. On the left, that's an ingredient list for blueberries. And on the right, that's a chemical structure for cocoa beans. So already we're encountering an area in which we're having consumer confusion from the very base level of what is clean. So not only can consumers not agree, but media cannot agree. So here you can see 3 different places where they call out clean beauty. And Harper's Bazaar has a definition of clean that it's safe for people and the planet. Clean means a beauty product should have considered human and environmental health. They use non-toxic elements as a baseline and plant-based ingredients for active results. On Oprah Daily, they say clean beauty means the formulas contain only natural, non-toxic ingredients, with non-toxic in quotes. And in the Washington Post, they say that it doesn't incorporate synthetics, and they've been deemed safe for the people and the planet. They're chemical free and they're natural. Well, I think all of us who are on this call today know that natural is a unregulated term, just like how clean is an unregulated term. But we do have a regulation related to toxic and toxic chemical. And this can be found in 18 U.S.C. 229, U.S. Code 229. And they're referring to toxic chemicals as a chemical action on a life process which causes death, temporary incapacitation, or permanent harm to humans or animals, regardless of the origin or the method of production, and regardless of whether they're produced in facilities and munitions elsewhere. So here, with our working definition that we have in the U.S. Code, we have toxic defined as something that is causing a very serious adverse event. Toxic also can be natural or unnatural, which makes sense because natural ingredients such as arsenic are toxic. So here with this working definition, we can see that of course you don't have these in your products of what toxic is. And in fact, it lines up pretty closely with the definition of an adulterated cosmetic. And an adulterated cosmetic, which is banned in 21 U.S. Code 361, says that it's an ingredient, it's a cosmetic that has an ingredient that is poisonous or deleterious substance, maybe filthy, putrid, decomposed substance, prepared and packed in an unsanitary condition. The container is composed of poisonous or deleterious substance and it's injurious to health. And as you can see, the regulations are already supporting if we're going to use toxic as a baseline for what if it's included or not included, as our baseline is, we're already clean. So we don't have toxic ingredients. But we know for a fact that consumers expect more for clean. And so now we're struggling to create a definition for clean. And so there's no regulatory agency in the United States that has defined clean. The FTC has not defined clean in the green guides. The FDA has not defined green in the new Modernization of Cosmetics Regulation Act of 2022. And in fact, this has left a gap in the industry. So many of you are aware of these dirty lists where brands themselves or third parties are defining clean to them. They're trying to create their own definition and terminology about clean. And a lot of these are coming from different ways. So the dirty list, for example, cites that they're one of the first clean lists. So Credo's dirty list has over 2,300 ingredients that they define as dirty, as not clean. They say they're even safer than Europe because Europe only has 1,700 ingredients. If you ever have the opportunity to go through the banned and prohibited lists of ingredients in Europe, you'll see things like human placenta, alkane fuel, things you would never put in a cosmetic because it would be adulterated. They're already banned. So, you know, the numbers game of I have more banned than you do isn't really sufficient if it never would go into a cosmetic. Also, Whole Foods Market. So food providers have a clean beauty section. And so they say they have 215 ingredients that are banned and counting. Also, you have Target's clean list, which has a list of ingredients that you can see down below where they say, if you don't have this, then you're clean. There's also third parties where you're going to start seeing seals of approval, like the Environmental Working Group, where they verify that the product is good for your health based upon the banned ingredients that they know. And they restrict if you want to have the seal. And then the detox market goes even further and they give a guide about every single product and if it's dirty, if it's clean, and why. And all of this is confusing consumers. You know, just a bare minimum, 215 does not equal 2,700. So there's a lot of customer confusion on what ingredient is bad and what ingredient is good. And we're having a lot of problems here. So this is these claims are where we intersect now with how we regulate cosmetics through U.S. advertising law. So
absolutely. Thanks, Claire. Yeah. So as Claire mentioned, she used a few important buzzwords: confusion, claims. These are all aspects of advertising law. And before we get into some of the aspects of how advertising law treats or may treat clean now and into the future, we thought it might be helpful to give just a high-level overview of the framework of the advertising laws in the U.S., because there isn't just one specific statute or case or regulation that governs this area. So U.S. advertising law is, as I mentioned, a web or framework of various different laws. There are federal, state, local laws, both statutes, regulations, and also case law, law decided and formed in the courts. A few in particular that are relevant to cosmetic industry and clean beauty, as we will get into further, are some of these that we've listed here on the slide, which I'll run through very quickly. The Federal Trade Commission Act. Now, this falls underneath the FTC, and the FTC, the Federal Trade Commission, they're the primary federal consumer protection agency responsible for regulating advertisements in the U.S. Some of you have heard of the FDA, the Food and Drug Administration. So the Food, Drug, and Cosmetic Act is what gives authority to the FDA to oversee the safety and labeling of, as is in the name, food, drugs, and cosmetics. Also covers devices like medical devices. So compared to the FTC, which regulates advertising claims generally, the FDCA regulates cosmetics in terms of their labeling and other related claims. Another big aspect of advertising law, and something that I'll be getting into a little bit later, is trademark law. So the Lanham Act is the federal statute that creates the regime for trademark law in the U.S. Sometimes it's referred to as a Trademark Act. And aside from this statute providing for the sort of foundation of our trademark laws, it also provides some interesting causes of action or rights of action under advertising law. The first is that it provides a private right of action to individuals, so you and me, who have been damaged or believe they've been damaged by the use of any false description or representation in connection with a good or a service. And then separately, it also provides companies with a federal cause of action against false advertising by their competitors, so company against company. And this is with respect to false designation of origin. So you can see designation of goods and false designation of goods. This is something that touches on trademarks generally. And as you can see, there's significant overlap in the advertising side. And then lastly, case law. So the law decided and formed in the courts of the US. We're going to be getting into a number of those cases as well. But one thing to keep in mind, and I think you'll notice throughout this presentation, is that there's a lot of repetition, as I'll get to in just a moment, across a few of these different regulations, but also, as you'll see, there is a common theme in terms of the general rule, which we've sort of extracted, and you'll likely see across the following slides, which is that advertisements in the US must be truthful, cannot be deceptive or unfair, and must be evidence-based. And by evidence-based, we often use the term substantiated or claim that you must substantiate a claim. This is where a company would identify sort of data through testing to confirm that something has the kind of efficacy that they're claiming within the advertising claim. But we'll get to that a little bit further in the following slides. Now, just breaking down some of this framework a little bit, under the FTC Act, this sort of creates or forms sort of the pillar of advertising law in the US. And again, the general rule here is that advertising, must be truthful and non-deceptive. So what does that mean? An advertisement is deceptive if it contains a statement or omits information that is, one, likely to mislead consumers acting reasonably under the circumstances, and two, that it's material. Material meaning that it's likely to have some actual impact on their decision to purchase a good, or to use it in a certain way, or to interact with it, or to buy one product over another. Now, looking into the Trademark Act or the Lanham Act, the FDCA kind of converges a little bit here. Now, the U.S. Supreme Court confirmed in 2014 that a private party can bring a Lanham Act claim challenging a label that's regulated under the FDCA. And the FDCA requires that product labeling and other marketing communications be true and complete. Again, you're hearing a lot of repetition. Prohibits misbranding and provides a range of civil and criminal enforcement mechanisms against inaccurate labeling. Claire's going to be talking about misbranding shortly. And then it gives the FDA authority to require certain information on product labels. So this can be, anything from side effects to the requirements in weight or quantity, etc. Now, the Lanham Act, as we mentioned, provides kind of two rights or causes of action, one for individuals and one for companies they feel that they've been damaged by a competitor through false advertising. Now, this second component under Section 1125A requires a showing of injury to the commercial reputation or the sale of goods or services by a company, and it requires causation, so that activity actually caused the plaintiff to be injured in some kind of way. Now, federal courts have typically taken this a little bit further, and they look to 5 main elements as part of this analysis. First, the defendant has made a false or misleading statement, fact, concerning their own or another's goods or services. The statement actually or tends to deceive a substantial portion of the intended audience. The statement is material, that it's likely to influence the deceived consumer's purchasing decisions. And the advertisements were introduced into interstate commerce, and there is some causal link between the challenge statements and the harm to the plaintiff. The causal link is number 5 that I mentioned. I think we consolidated them there. But we'll mention also very briefly interstate commerce. This is another sort of cornerstone of federal trademark law in the US. This is where trademark rights originate out of use across state lines. So it's not within an individual state. So it's at the federal level, in short. And again, the causal link, there must be a connection between the activity, the act or omission, and the damage or injury to the third party. And so Claire now is going to get into a little bit more about misbranded cosmetics as we kind of narrow down the focus of this framework into the clean beauty space.
Yeah, thank you. So while we have 361, a cosmetic cannot be adulterated, we also have 362, that a cosmetic cannot be misbranded. And this is where you see that overlap with the Lanham Act. So a cosmetic would be misbranded if its labeling is false or misleading in any particular. So any claim that is being made that would mislead a consumer, and a misleading claim, it has a very clear definition legally in that it's equally open to true or false interpretations by the consumer, and it's ambiguous. So that's sort of where the issues with clean comes in, because the consumer's point of view is so convoluted that you're not able to determine if this is true or false. Misleading statements can't be entirely false as well. So when you're thinking about making a claim that is a clean claim, the courts have held up that a claim that is literally false is in violation of the Lanham Act. But it's important to know that false claims, it means deception is presumed, and misleading claims mean the plaintiff must prove deception. So the plaintiff has to prove that they were misled because of this clean claim to purchase this product. And a false claim is that deception is presumed, that it is not clean. And since there is no definition of not being clean, that is something that false claims is not something on the table. Misleading claims is now on the table, and we have to prove, the plaintiff has to prove that they were misled into making a purchasing decision. So if an advertiser's message relies to a great degree on the consumer's ability to draw a conclusion, it's also less likely the court will find it literally false. And all of this analysis is always done under the reasonable consumer standard. And also we should note the reasonable consumer standard, which we'll talk about later when we talk about Sephora, is also under scrutiny in the courts. So there was a case, Kerry Miller et al. Versus Peter Thomas Roth LLC et al. And the consumer said they were misled into purchasing this Peter Thomas Roth Labs rose stem cell and water drenched lines. So the rose stem cell line was marketed with buzzwords such as biorepair, reparative, rejuvenates, and regenerates. And the water drenched line was marketed as containing hyaluronic acid, which attracts and retains 1,000 times its weight from water, from moisture in the atmosphere. So based on these two claims, two consumers, the plaintiffs in this case, said they purchased the product and that they were deceived, and these misleading claims were not true. That there was deception that occurred, and that is influenced their purchasing decision. So the court considered this under a state law, under the California Unfair Competition Law, that prohibits not only advertising which is false, but also advertising which, although true, is either misleading or which has the capacity, likelihood, or tendency to deceive or confuse the public. And this is that gray area for clean beauty that we're operating in. So based on these ads, the marketing materials that were available in store as well as online, and the product packages themselves, the court found that the reasonable consumer would believe the claims being made by the company. And the court explained this, saying the reasonable consumer is not expected to look beyond the misleading representations to uncover the truth from the ingredient list in the small print on the side of the box. Also, the court inquired into whether the product performance said it did what it said it did. The court accepted expert testimony, so they had experts come in. There was third-party testing that occurred on these products to prove their efficacy. And they had a through line in terms of they measured moisturization. Moist skin then would be less likely to be damaged. And so that's how they had the rejuvenation reparative claims, is they had a moisturization effect. Therefore, it's less likely, moist skin is less likely to be damaged. This was from the experts who testified. But since the claims on the product could not be substantiated because there's no test that exists that say reparative. There's no test that exists that says rejuvenates. There's no measurement for regeneration. So the claims on the product, they said, were not able to be substantiated. And based on this, the court deemed the creams to have no effect on the skin. They had an effect. They just didn't advertise the effect that they measured. And so here we find ourselves in a very difficult position to extrapolate the reasoning of this case. So we can see why clean beauty consumers cannot rely on courts to redress the confusion created by the companies in the market. So a consumer may be able to show an unfounded belief has occurred in the interpretation of label on the product. And this is a belief that the clean products are generally better than other products. Because it's clean, I perform better. Because I have naturally derived ingredients, I am better. And when compared to other products that don't have any of these clean claims, when compared to other products lacking certain labels, the label is technically correct. More specifically, if a product says it's free from parabens or something, that's a claim you see everywhere, and it turns out it contains parabens, consumers will have a claim. They can prove the statement was false. That's logical. But if a product is free from parabens and the product is indeed free from such chemicals, consumers do not have a claim. So there you can see the false true dichotomy. So with some clean claims, there is a false or true dichotomy. With other clean claims, there's no dichotomy that exists in which the consumers would have a reasonable basis. But if we extrapolate that reasoning and we use fragrance-free as an example, which is a very common claim you see in the clean beauty world, fragrance-free relies on the awareness of a consumer from the advertiser's confusing part to whether an advertisement is implicitly false, and it's very problematic. So it doesn't sound like it would be hard. So when we break it down, it actually is. So company A has a new product that is fragrance-free. And the facts are that it doesn't contain the ingredient fragrance in the INCI list. So it is free of the word fragrance. It's free of a fragrance being intentionally added. However, here's where the confusing part comes in. There's other ingredients within the formulation that have a natural sweet smell to them. So they have a natural ability to have two purposes. So one of those is phenoxyethanol. Phenoxyethanol is a very efficacious preservative. It's used a lot in clean beauty, mostly because they've taken every preservative from us. So phenoxyethanol is used as a preservative. And then phenoxyethanol has another purpose in that it is very sweet smelling. So it can be a masking agent. So if I wanted to carry this fragrance-free claim, this is kind of a little bit difficult because I have ingredients in my formula that have a fragrance to it. I'm not including a fragrance, the INCI fragrance. So putting emphasis on the facts regarding the consumer awareness and the marketing department is privy. gives the company green light to continue relying on true statements that may lead to false assumption in the minds of some consumers. So brands have been addressing this ambiguity should be simplified with more direct statements. So this is where you see free from synthetic fragrance. Even that is a little bit challenging. Free from added fragrance. It's becoming more less ambiguous and more clear in what it is free of, rather than this catch-all fragrance word, because anything could have a fragrance if it's added into the product. So this ability to remove the customer's confusion and be more clear in what you're claiming is very apparent in the natural world. So Love Beauty Planet has identified itself as a clean brand. And on their label, they don't say naturally derived. They don't say this whole product is naturally derived, because then you may be insinuating that also the container is naturally derived. Instead, they say 93% of the ingredients in this product are naturally derived. Then they give a definition, what we would call a disclosure statement. They give a disclosure statement defining how they say this is naturally derived. And they've indicated in their ingredient list the ingredients that are plant-based. And what they're doing is they're basing this on an existing standard. So the existing standard is called the International Standardized ISO 16128. And this existing standard is not a law, it's not a regulation, it's just something that has been accepted within the industry to provide clarity. And this is where it gives very clear parameters for a beauty brand or a raw material provider to define the naturalness of an ingredient or a formula. They take into account physical processes, like cold press, squeezing, dehydrating. They also account that fermentation reactions occur in nature. Therefore, fermentation is a clean process. And they also talk about solvents that can be used in extraction that can make a product naturally derived, and solvents that could not make a product naturally derived. So there is some issues with this in which other third parties hope to address, such as EcoCert. So you may see EcoCert certified or something like that. They have a different definition of how they define naturally derived ingredients. But here you can see Love Beauty Planet, their definition that they have on the package aligns with the definition of ISO 16128. So it's a very clear, measurable result. And so this adequate disclosure was something that a lot of brands were going with Clean, to remove the ambiguity, remove the customer confusion, being very clear on how they made these claims immediately on the package, not on an additional information such as the website. The user didn't have to go anywhere else. They had it immediately there at point of purchase to understand how they defined what they said as clean. And then we had a huge curveball thrown in. And that curveball is the Sephora Finster case. So we're going to have Ariba talk about the facts related to this case and how it applies to clean.
So the curveball, as Claire just mentioned, comes to us from the Northern District of New York, where a class action was filed last year alleging that makeup retailer Sephora's Clean Beauty program is false and misleading. So Sephora developed this Clean at Sephora program that is denoted with a green seal affixed to certain products that Sephora promises are formulated without specific ingredients that are known or suspected to be potentially harmful to human health and or the environment. As Claire has touched on, harmful ingredients could encompass a wide range of chemicals or materials. But what's different about this case is that we don't have to guess what ingredients Sephora considers harmful, because they actually disclose the ingredients that they are protecting consumers from. So that list includes over 40 ingredients. The heavy hitters are listed there on the screen: phthalates, formaldehydes, oxybenzone, many others. But despite this disclaimer, Finster is still alleging that the Clean at Sephora seal includes products that are inconsistent with how consumers understand this term. So specifically, Finster asserts consumers who see claims about a clean product expect the product to be consistent with the dictionary definition of clean, which defines clean as something free from impurities or unnecessary and harmful components and pure. So now I'll hand it back to Claire so she can give you more details and discuss the ramifications of this case.
Thank you. And really what it goes down to is what Finster is saying is the definition of clean. There's no regulated definition, but they're saying this is the definition of clean that everyone understands. And they pulled it from Merriam-Webster dictionary. And they said clean is something free from impurities or unnecessary and harmful components, and pure. So in this context, that means that they allege that products made without synthetic chemicals and ingredients that could harm the body, skin, or environment are clean, and that the products that carry the Clean at Sephora seal contain these ingredients that they're not matching with the definition that they know of as clean. But there's a lot of problems with this. So one of the problems is the ingredients that they specifically cite saying these are not clean. So stearic acid, for example, is the most common long-chain fatty acid. It is predominantly derived from coconut or palm. It's a major component of cocoa and shea butter. That's why it has hydrophobic abilities. So that's why when you put it on your skin, the water doesn't penetrate, but it's very good at sealing in moisture. And the process that you use to make stearic acid is either through a pressing method or through hydrolysis. And that's where Finster has an issue. They say hydrolysis is a chemical reaction. And if you break down the word hydrolysis, it's actually water being introduced to your product and breaking down the product into its different components and then fractionalized, so removing the one component from the other. So here, the consumer is saying, Finster is alleging that the consumer will believe this chemical process, even though it's water being added or it could be cold pressed, is making this a synthetic. They also cite xanthan gum, which, sorry, apologies for the misspelling. Xanthan gum is actually very widely studied. So if anyone is gluten-free or suffers from celiac, you're very familiar with xanthan gum. It is something that is used as a thickening agent in the absence of gluten. It is approved by the US FDA as well as in Europe. So I know a lot of people would like to say Europe is safer. So if we'll give you xanthan gum. And they're saying that that is a synthetic ingredient. And they said produced by a chemical reaction. Its chemical reaction is fermentation, where I can see if fermentation is no longer declared to be something that is natural, the beverage industry would throw a fit. So saying that this ingredient is not is made by a chemical process is not really entirely true. Again, it is a chemical process. Anything is a chemical. Water is a chemical. I often like to say, if you take in too many chemicals, such as water, you will die. It's called drowning. There's tons of different ingredients that are called chemicals because that is the word that we use. But just because it undergoes a chemical process doesn't mean it's not a clean process. But that is what Finster is alleging in the Sephora case. And they're also saying, Sephora went back and pushed back and said that the Clean at Sephora makes no representations about what is included, that they only spoke about what is not included. And so therefore that their definition is what's not here rather than what is there, because it's too many ingredients for them to go through to say, that one's fine, that one's fine. They're saying if you include these, this is not okay. So here you can see we're all waiting on what the court is going to find. If the court dismisses it, that'll be really great for industry because it was dismissed on grounds of Sephora pushing back saying about the declaration. Also, Sephora had a really great statement in their motion to dismiss. They said that Clean at Sephora means Clean at Sephora and that it doesn't include ingredients. But also, they said the Finster is alleging they want to make it natural at Sephora, which is not a claim they're making. They're not making any natural claims. They're not making any organic claims. That the marketing focuses solely on the exclusion, and clean does not equal natural. And so that's a very interesting and very distinct piece that we should consider because consumers are equating natural with clean, even though there's no regulatory, again, definition. So is that true or is that not true? That is in the courts right now. So some of the key considerations that I advise in my practice of working with brands is, developing a practical roadmap to limit risk related to your products or your product lines that you intend to carry clean claims. So the first thing I always ask a brand is for them to define what clean means to you, so we can understand like how they're going to use this word in advertising and branding. And then once we have what clean means to them, we define it very clearly for the consumer and for internal usage. So we have a disclosure statement for the consumer, but then we find any established standards, any established regulations to support that definition, to have substantiation supporting what clean means to the brand. And then we implement the definition throughout advertising and product labeling. So we have disclosures available to consumers at the point of purchase in order to not confuse them, to make it clear on what is clean to the brand. Also, we apply the definition to all of the products in a consistent way. There's no exceptions. So, for example, dandruff shampoo would have an ingredient that people would define as not clean. You have to be very clear that you can't include clean on your display and put the dandruff shampoo in there because it doesn't match your definition of clean. So there you would have to specifically call out that an ingredient is not clean, that is in there, that does not match your definition. And you also need to ensure that any product that does use this clean abides by the definition with 100% conformity. You can have no ambiguity to the consumer of, well, in this instance, we did this. So this is usually a practical roadmap we use to limit risk. Again, there's no such thing as no risk. Everything has risk, but here is a way to limit the risk and exposure to your brands to make sure that consumers are not confused on the words that you are using and how you are supporting those claims.
Thanks, Claire. Now we're going to pivot just slightly to intellectual property. And first, we're going to be getting into patent law, and Brad and Kiri Lee are going to be addressing this area. So Brad, I'll hand it off to you.
Thank you, Ari, and Claire, thank you as well. While clean and natural beauty products may be great from a marketing perspective, this can create issues with obtaining a patent, particularly in the United States. Over the past 10 to 15 years, increasingly patent law in the U.S. has become focused on patent eligibility. And there the focus is whether or not something falls into one of the 4 areas of patent eligible subject matter, which the statute defines as process, machine, manufacturer, composition. And the Supreme Court has held that natural products do not fall into one of these four categories. That said, it would be nice if you have a natural product that's doing well to obtain patent protection for it. So this raises the issue of what is necessary to transform a natural product, such as a clean beauty product, for example, a natural fragrance, into patent eligible subject matter. And
Sorry,
before
Brad,
we go on, I'll let Taylor step in.
Thank you. Yes. Pardon the interruption. I will announce the CLE code for today's presentation at this time. For those of you seeking CLE credit, please record the following 5-digit code on the polling slide and attorney affirmation form if applicable. The code is DSUAA. That's D as in Delta, S as in Sam, U as in uniform, A as in alpha, A as in alpha. That's DSUAA. And we'll turn it back to you, Brad.
Thank you. And so I want to run through what the Federal Circuit has told us about what's necessary to make this transformation, and maybe sometimes like what they have not told us. But the first case I want to bring up is a 2018 case in Baguette, and the Federal Circuit there held that claims directed to nutritional compositions containing fatty acids were patent ineligible. And there, the patent claims were directed to limitations, or had limitations. Like their nuts or oils were extracted or obtained from almonds, peanuts, and coconut meat. And the key issue there was whether or not the mere sort of act of extracting like fatty acids from an almond would be sufficient to confer patent eligibility. And the court disagreed with the patent applicant and held that that these claim mixtures are not a transformation of the natural products, and these claim mixtures have properties that are possessed by natural products. There hasn't been this there are no unnatural properties. So then a year later in 2019 in Natural Alternatives v. Creative Compounds, the Federal Circuit addressed another issue, and this one was at the motion to dismiss stage. In there, they found that method of treatment and composition claims that recited an effective amount of beta-alanine to be patent eligible. They at the motion to dismiss, the district court erred in finding them patent ineligible. And as to the method of treatment claims, the court found that the claims used a natural product in unnatural quantities to alter a patient's natural state to treat a patient with specific dosages outlined in the patents. And similarly, as to the composition claims, the court found that the claims were directed to specific treatment formulations there that incorporated natural products. And the key thing that the court seemed to be getting at there was they recited like the particular dosage or quantities of the sort of natural compound, and as a result that the limited claims did not claim something that would otherwise be found in nature. And then recently, in earlier this year, in early 2023, in Chromadex v. Elysium Health, the court addressed another natural products issue. And this one was directed to milk, and it's a similar issue probably could come up in many natural products in the cosmetics industry. In there, the claims were directed to dietary supplements containing isolated nicotinamide riboside, or NR, a form of vitamin B3 naturally found in milk, albeit in non-isolated form. So the claims claimed an isolated form of NR, and NR could be found in non-isolated form in cow's milk. And in finding the claims patent ineligible, the court explained that to be patentable, the claimed composition must have, quote, markedly different characteristics and have the potential for significant utility. And then the court went on to hold that the claimed composition remained indistinguishable from natural milk because, other than separating from some other components, the isolated NR is no different structurally or functionally from its natural counterpart in milk, and thus are patent ineligible. And there, what the courts seem to be getting at is just claiming and something that could be found in milk, and then isolating it would not be enough. And one other key part about this case is this court specifically noted that the claims were broad enough to cover sort of both unnatural versions of isolated NR and sort of versions of NR that could be found in, for example, milk. And because the claims were broad enough to cover natural things that could be naturally found in milk, the court found that that was sufficient for a finding of patent ineligibility. So with this in mind, and based on our experience, we have a couple takeaways. And the first one is, when a natural product is at issue, the first thing is the claims must recite some meaningful transformation from what is natural. For example, as in the natural alternatives case, specific quantities that are not naturally found. For example, like a dosage of 4 milligrams to 16 milligrams, I think was what they found to be patent eligible there, or reciting an effective amount. And one other thing that can further help that is in the specification, it's not merely to have the claims recite unnatural quantities, but also have the specification explain sort of like what amount of a particular composition would be naturally present versus what is necessary to make sort of like the claim limitation, or how you're basically establish how your claims are going from sort of natural composition to an unnatural composition, such that they have markedly different characteristics from naturally occurring products. And with that, I'm going to turn it over to Kiri Lee Sharon to give you an update on a patent issue in Europe.
Thank you, Brad. I wanted to quickly highlight some ongoing European patent litigation and a decision in a European patent opposition proceeding. With the disclaimer that I am not a European patent attorney, I think there are some issues that are relevant for both US and international patent applicants in the beauty space and other fields. The patent in suit here, the 127 patent, relates to compositions to protect the skin from infrared damage and was involved in multiple litigations in Europe, including Germany and Switzerland, together with a related patent. The patent is owned by STADA, a German pharmaceutical company, which markets sunscreen under the Ladeval product line in several European countries and the Middle East. STADA touts that its products provide pure sun protection and are free from fragrance, artificial colors, and preservatives, for example. I won't attempt to parse the distinction between clean and pure. The issue in the European proceedings do not turn on any kind of purported purity, but rather on the effects that STADA was claiming in the patent. By way of background, STADA brought suit against its competitors alleging patent infringement. Some have speculated that STADA timed its suit to try to push competitors' products off the shelves right before summer when sunblock sales would surge. And in response, various competitors from pharma companies that have drugstores, private label production and contract filling companies, and retail companies, a broad spectrum of interested parties, if you will, filed opposition proceedings to seek revocation of the patent. Turning to Claim 1, the only independent claim, this claim recites a pharmaceutical composition comprising an effective amount of antioxidants for use in a method of protecting the skin from damage by IR radiation, where the damage is caused by activation of a specific enzyme. And just looking at this claim language, a few points jump out. There's no specificity about the type of antioxidants, any particular dose or dosing regimen, or even any type of IR exposure specifically. You'll note that the product label right below on the slide that was on some of the Ladeval products calls out infrared A, whereas the claim just says infrared. The European Opposition Division, in its decision about this patent, referenced multiple times a recent decision from the enlarged Board of Appeals of the European Patent Office relating to plausibility, which is a judicial doctrine in Europe. In short, this decision related to the admissibility of evidence submitted after a patent application is filed, which can be submitted to show that a technical effect is actually achieved. And the decision specifically concerned the use of post-filed evidence to support that an invention meets the inventive step / non-obviousness requirement. This 2023 decision, which came out after, in the middle of this litigation, clarified that this type of evidence can't just be dismissed out of hand, and that if the skilled person, in view of common general knowledge, would consider the technical effect to be, quote, encompassed by the technical teaching and embodied by the invention as filed, then post-filed evidence of technical effects can be considered and relied on. There were a host of arguments relating to what the patent owner had shown about the claimed effect, including whether the evidence truly showed that a person of skill in the art would have known that the damage, the skin damage, was specifically caused by IR and not UV light, because when you're exposed to the sun, you get multiple types of radiation, and also about the particular mechanisms and the relationship between infrared light exposure and the enzyme responsible for causing skin damage. With reference to the recent decision on plausibility, the European Opposition Division found that the evidence wasn't sufficient in view of that very broad claim, and they noted the lack of any kind of detail about the antioxidants in particular. So the patent owner has filed an appeal of the decision, so this is not the last we will see of this case. Some takeaways here are that it's very common in the life sciences and pharma fields to want to file early because of a journal publication, a trade show, or other public disclosures, and to try to avoid additional prior art. Later filed evidence is most often submitted in these fields, but it can come up in other areas too. Different jurisdictions vary in their approach to post-filed evidence. The US is more lenient. Some Asian jurisdictions can be very strict. Europe is often described as being somewhere in the middle. So being mindful of these differences is important, knowing that different standards and doctrines apply, and it can be helpful to try to draft patent applications, being mindful of these different standards and including content that provides a nexus or hook between the claimed subject matter and the technical effect achieved.
Thank you, Kiri. We're coming up on the hour, so I'm going to move somewhat quickly, but we're coming back now to trademark law. I had originally raised trademark law when we were talking about some aspects of advertising law in the U.S. The Lanham Act, the Trademark Act of the U.S. covers both the general framework for trademarks and trademark eligibility and related considerations with respect to trademark rights, and then also false designation claims under advertising law generally. So what is a trademark? Many of you know, many of you are familiar, but it's a word or phrase, mark, logo, some insignia that indicates the source of a good or a service. And we had talked about briefly eligibility, what is eligible for or what can be entitled to trademark rights, federal trademark rights in the United States. I had mentioned interstate commerce. That's one important factor. But one I want to focus on here and with respect to clean beauty is descriptiveness. So the general rule, and there are exceptions, but I won't get into them given the timing. But the general rule is that a mark that is not distinctive, but that is descriptive, meaning that it describes the good or service, is not entitled to trademark protection in the US. So if I want to create a shampoo product and I want to call it shampoo, now that's a really ridiculous example, but that's actually a generic, it's descriptive and even generic for what the product is. So I can't exert and enforce my rights in the term shampoo against other companies that sell shampoo and describe their product as such. Now, looking into clean and trying to tie this together, the USPTO, US Patent Trademark Office, has routinely required for disclaimers to be applied for certain terms as part of trademarks, like organic or natural. That's a sort of parallel. Organic and natural because those are generally understood terms, whether they have ISO standards or they're just commonly understood to have a meaning. The USPTO requires that applicants file a disclaimer, which is that it's essentially an affirmative statement that you are not claiming exclusive rights in that specific element of the trademark overall. So if I have a shampoo called, Ariane's shampoo, or let's say Ariane's 123 ABC organic, they may require me to disclaim the term organic because it's descriptive of a feature of that product. Now, we've noticed in our review and in our practice, these kinds of terms, organic, natural, et cetera, are required to be disclaimed. But with respect to clean, and a common, topic that we've discussed here is that there's really an uncertain definition of what that means. The USPTO, through our review, hasn't routinely required for the term clean to be disclaimed in a number of marks related to beauty and cosmetics. And we think this could be for a number of reasons, but likely because it's not such a definitive term yet. It's still used somewhat fancifully, or at least in a way that is used to incorporate in branding in some kind of unique or clever way. But it maybe doesn't strike the U.S. Patent and Trademark Office as extremely descriptive, like organic and natural. And that could be because it's gaining in popularity, but it's maybe not a common household term yet. The reason why this is important and why we flag this is because, as clean develops a definition over time, and as the regulations and guidance, provides more clarity, we expect for the U.S. Patent and Trademark Office to deem the term clean as exceedingly descriptive. And what that means in terms of practical sense of branding and strategy around your branding is that the incorporation of the term clean in advertising, as we discussed before, is one consideration. But the second, when it comes to using it in your brand strategy to kind of create terms for your brand, a brand name, product name, a collection name, if you want to be able to exert rights in that name, incorporating the term clean could slightly undermine it or weaken the trademark because you're incorporating a descriptive term, and descriptive terms in and of themselves are not inherently strong. And very quickly, just taking a look at this trend, we noticed that in 2022, there were around 562 applications and registrations for clean, or clean formative marks, rather, marks that include the word clean. And then this year to date, we have around 643. So just to show that we expect for more of these marks to be on file and for the U.S. Patent and Trademark Office to treat them as exceedingly descriptive over time. So we're going to turn it over now to Claire, who's going to give us sort of forward-looking perspective into clean beauty and what we can expect down the road. Thanks.
Thank you. So what is coming up in clean, I think, is PFAS. Everyone's probably heard of this buzzword. It stands for perfluoroalkyl or polyfluoroalkyl substances. They're known as the forever plastics. On November 30th, into the House, the No PFAS in Cosmetics Act was proposed, requiring the FDA to ban the use of intentionally added PFAS. Also, the FDA in the new MOCRA requirements is going to be releasing in 2024 a PFAS study. Judging by who you speak to or what regulatory body you're talking to, PFAS is a family of chemicals between 5,000 and 15,000 ingredients. The Organization for Economic Cooperation and Development has released a study saying it's over 4,700 chemicals. The reason why PFAS are being found in cosmetics is actually because they are found in the most common ingredient in cosmetics, which is water. PFAS has been found in rainwater. PFAS is found in fish. PFAS has been found in human blood. PFAS is pretty ubiquitous. So we're waiting on further clarification from the regulatory bodies on how this is going to be regulated, with it being so omnipresent. Also, going into the future of clean is sustainability. So, clean used to be what's not there. The new way of looking at clean is, what do you do with the product when it's done? So you'll hear a lot of PCR conversations, post-consumer recycled plastic, a lot more aluminum, because aluminum is the #1 material that's recycled. So sustainability practices, ethical practices within the supply chain are something that is coming up very frequently, and something that you should be looking at and working with your supply chain teams to help support in the same way that you support any sort of claim in terms of substantiation. And there's going to be a bunch of requirements that are coming in 2024. So these are a list of the PCR and EPR requirements. EPR means the extended producer responsibility. So basically bringing in a material into a state will have a associated fee so that the state themselves can increase the ability to recycle, because the recycling programs are so underfunded in the United States. For example, there's only 11 facilities that can recycle aerosol containers in the United States. So a lot of these bills are focusing on us, the providers, who are giving people these products. When they dispose of them, we have to pay a fee to these people. It's a little bit difficult in terms of identifying what fee you pay, but these are primarily focused on plastic materials. So if you're making a lot of materials with plastic, you should definitely look into the EPR related bills that have been passed in certain states to understand if you can comply with those requirements or how to comply with those requirements. And then, of course, if you have any questions, please feel free to reach out to any one of us. I work regularly with beauty brands, so I would love to talk to you about your regulatory and quality programs to help support a lot of your claims. And the Foley Fab group, the Fashion Apparel Beauty, is always here for you to talk about any of your legal concerns related to clean beauty and other beauty areas in which you have questions. So I definitely want to thank everyone here for joining us. And it's been a pleasure to have a clean beauty seminar, and I hope everyone got something out of it. So thank you.
Thank you, Claire. I know we've gone just a little bit over, so if anyone can stay on and has any questions, please let us know.